Welcome to our video on the Colorado Privacy Act, or CPA. Today, we'll dive into the scope and key provisions of this comprehensive privacy law that's reshaping how businesses handle personal data in Colorado. The CPA is a comprehensive privacy law that was signed into law on July 7, 2021. It established new standards for personal data collection and use, and offers significant protection for Colorado residents' personal data. The CPA applies to data controllers that conduct business in Colorado, or produce or deliver commercial products and services targeted to Colorado residents and meet either of the following criteria: control or process the personal data of at least 100,000 consumers annually, or derive revenue or receive a discount on the price of goods or services from the sale of personal data, and process or control the personal data of 25,000 or more consumers. The CPA enhances protection for Colorado residents by granting them several rights. Data subjects can request to confirm if a controller is processing their personal data, access their collected and processed personal data, correct any inaccuracies in their personal data, have their personal data deleted, obtain a portable copy of their personal data for the purpose of data transfer to another controller, opt out of personal data processing for targeted advertising, sale of data, or profiling that results in significant effects concerning the consumer. Under the CPA, controllers must provide consumers with an accessible and clear privacy notice. It should include the categories of personal data collected or processed, the purposes for which it is used, how consumers can exercise their rights and contact the controller, whether personal data is shared with third parties, and the categories of third parties with whom is shared. This ensures transparency and informs consumers about the handling of their personal information. If personal data is sold or used for targeted advertising, clearly disclose this and explain how consumers can opt out. Prior to engaging in processing that presents a heightened risk of harm to consumers, controllers must conduct and document data protection assessments. Processing that presents a heightened risk includes processing personal data for targeted advertising or profiling that could result in unfair or deceptive treatment, financial or physical harm, intrusion upon privacy, or other substantial injuries to consumers, selling personal data, and processing sensitive data. Data protection assessments must identify and weigh the benefits that may flow, directly and indirectly, from the processing to the controller, the consumer, other stakeholders, and the public against the potential risks to the rights of the consumer associated with the processing, as mitigated by safeguards that the controller can employ to reduce the risks. It is important to note that the controller shall make the data protection assessments available to the Attorney General upon request. The CPA imposes some restrictions on controllers. They must not collect unnecessary personal data from consumers or process it for purposes beyond those initially disclosed without obtaining consumers' consent. A controller must obtain consent from a consumer before processing sensitive data. For personal data concerning a minor child, consent must be obtained from the child's parent or lawful guardian prior to processing. Additionally, controllers must establish and maintain reasonable administrative, technical, and physical security measures to protect the confidentiality, integrity, and accessibility of personal data against unauthorized access. The Attorney General or District Attorney, or both, are responsible for enforcing the CPA. A non-compliant entity may be fined up to $20,000 per violation. In such a case, the controller will be served a notice and given a 60-day cure period. Certain types of data are exempt from the CPA. This involves data processed for employment or business-to-business contexts, including job applicants and employment records, free speech or household purposes, research, product improvements, or operational efficiency, compliance with legal obligations or cooperation with authorities, protecting vital consumer interests or responding to security incidents, public health reasons under specified safeguards, and professional confidentiality obligations. To learn more about global data privacy laws and how you can automate them, visit security.ai.